titles of the bills and resolution.
Bill number 180162, an ordinance to adopt the capital program for the 6 fiscal years 2019 through 2024 inclusive. Bill number 180163, an ordinance to adopt the fiscal 2019 capital budget. Bill number 180164, an ordinance adopting the operating budget for fiscal year 2019. Resolution number 180185, resolution providing for the approval by the Council of the City of Philadelphia of a revised 5-year financial plan for the City of Philadelphia covering fiscal years 2019 through 2023 and incorporating proposed changes with respect to fiscal year 2018, which is to be submitted by the Mayor to the Pennsylvania Intergovernmental Cooperation Authority, the Authority, pursuant to the Intergovernmental Cooperation Agreement, authorized by an ordinance of this council approved by the mayor on January 3, 1992, bill number 1563-A, by and between the city and the authority.
Thank you, Mr. Stitt. Today we continue the public hearing of the Committee of the Whole to consider the bills read by the clerk that constitute proposed operating and capital spending measures for fiscal 2019, a capital program, and a forward-looking capital plan for fiscal 2019 through fiscal 2024. Today we'll hear testimony from city departments. We will have the 1st Judicial District, District Attorney's Office, Law Department, Defender Association, and Aviation. That is quite a long list, so I'm going to ask my colleagues if we can do something a little different today so we can expedite this process early on since we're starting a little late. I'm going to ask if the first round or the first department, we can limit it to 1 round so we can kind of catch up, if that's okay. And I promise we'll be lenient on the bell. All right, thank you, guys. See no disagreements. I want to thank you all for your cooperation. Okay, the first person to testify today, Mr. Stitt, is
the Honorable Sheila Wood Skipper.
Thank you. Good morning.
Good morning, Council President, and good morning, members of Council. As you know, my name is Sheila Wood Skipper, and I am here today as the chairperson of our Administrative Governing Board and the President Judge of our Court of Common Pleas. And I am representing the other members of our Administrative Governing Board here today. Also in attendance with me is Kevin Cross, our Deputy Court Administrator for Financial Services, to help answer questions from members of Council about our budget. I should note, I understand that we're running a little behind schedule today, and I've been asked to keep this brief, and I will. You do have copies of our written testimony. We did provide you with a revised copy as there was an error on the last page, so I just wanted you to note that for your record. The mission of our courts is to adjudicate cases according to their jurisdiction and to ensure fair, timely, and accessible justice to the citizens and litigants in the city and county of Philadelphia. And that has been the focus of my administration, is to focus on access to justice and on setting goals and achieving outcomes for which we can be held accountable. We are here today requesting for fiscal year 2019 $161.7 million, which consists of $109.6 million for the general fund and $52.1 million for grants revenue, and this awaits your approval. As you know, the FJD saves and generates funds by crediting to the general fund $44 million for filing fees, $31.2 million for fines and costs, and $13 million in reimbursements. Additionally, we save the city and its agencies over $6 million annually by waiving filing fees in the Court of Common Pleas and Municipal Court. So in reality, we're really only requesting about $55.4 million, or a third of the total funding for FY19. I also should note that absent from the funding for FY19 is the 3% wage increase for our exempt non-union workforce. This wage increase was appropriated in our current FY18 budget and has not been released. At this time, I must strongly advocate on behalf of our affected employees to release these funds to our non-union employees who are earning less than their union counterparts and who are equally deserving of this long overdue wage increase. I should note that the FJD is a strategically focused partner in government. And one of the things I did last year was to implement a high-level team to develop a strategic plan for the 1st Judicial District. And I'd like to just focus on that very quickly. You all received a copy of that as well. The 5 tenets of this strategic plan include access to justice, expedition and timeliness, equality, fairness and integrity, independence and accountability, public trust, and confidence. And in the written report, you will see all the goals that have been set out and the outcomes that have spearheaded this effort to ensure that we are meeting the tenets of these goals, and we will continue to strive to do that. I'd also like to remind you that the FJD is also creating savings with other agencies. We are a cooperative and responsible partner in government by creating, collaborating, and implementing programs that streamline case processing and reduce costs to other agencies. Our involvement in the CJAP, MacArthur Criminal Justice Reform Grant Initiative, has generated savings by reducing incarceration lengths of stay. In 2015, I'll just say this statistic, the baseline Philadelphia prison population was 8,082. On March 31st of this year, that population has been reduced to 5,586, a reduction of 2,496 inmates, or 30.9%. The population is actually lower today. A number of factors have contributed to this reduction, but it's the FJD-led and cooperative MacArthur initiatives concerning early bail review, where individuals who are in custody on low bail amounts and no holding matters are provided with a hearing and can be released early on in the system. Also, we've generated a substantial reductions because of the electronic monitoring that was also a part of the MacArthur grant. In 2015, the average days in custody prior to being placed on electronic monitoring was 37 days. In 2017, it was 27 days. So we are slowly making progress in reducing the amount of time in custody. The MacArthur grant funding provided 700 new technologically advanced monitors that can be activated that will further impact the population in the prison. So we continue to evaluate other court programs to identify savings to other criminal agencies in the following areas: by creating reductions in prison transportation through video conferencing and using case management to reduce police officer appearances and overtime. As the MacArthur grant, as well as CJAP, continues to use and better identify individuals who are in custody and look at detainers on individuals to assess who can be released and at what time. We continue to work with our justice partners to address any issues and concerns concerning detainers, and it really is the philosophy of our department, Adult Probation and Parole Department, that we use detainers and incarceration as a last resort, as we are seeking to rehabilitate, not incarcerate. We're also looking at focusing on new justice initiatives that include the Language Access Plan that was adopted by the Supreme Court in March of last year. And as a result of that, we have been expending resources and funds to make sure that this plan is appropriately implemented. So during the calendar year of last year, we made sure that we provided telephonic interpreting, that we're able to capture early on in the system who needs an interpreter and make that available, and that we establish notice of language rights that are included in all hearing notices. We're also in the process of relocating our adult probation and pretrial services. In September, we entered into an agreement to relocate the offices from 1401 Arch Street to 714 Market Street. That building is now in the process of undertaking landlord is undertaking a complete refurbishment, including mechanicals, electronical, and plumbing systems, and we expect to occupy that building in the beginning of next year. We've also developed an attorney-client video same-day interview program in conjunction with the Sheriff's Department, where attorneys can can video conference with their clients in the building on the day they are scheduled for court. This eliminates bringing individuals in the courtroom where they're not necessary, but also it was a solution to the situation with the elevators there where there is no access to the basement by the lawyers. We've also established in our orphans court, a guardianship monitoring program where we now have a guardian investigator to review the inventory and annual reports filed by the guardians and to track their compliance with the statutory duty to file reports and ensuring that the guardian is really working in the best interest of the persons they are responsible for. In our family court division, we have implemented evening reporting centers to serve as a community-based alternative to detention or placement for our youth and to provide an extra layer of community-based supervision coupled with the GPS monitoring and providing additional services for our youth. In our municipal court civil division, we have created a courtroom navigator to assist unrepresented landlords and tenants with basic information about the court process. The navigator will also provide referrals to services and resources, and the court has also instituted revisions to the landlord-tenant complaint to make sure that it is in compliance with all of the local ordinances. We've also an ongoing dialogue concerning any issues and concerns with the Philadelphia Bar Association and the public interest groups that are involved. We also, in our traffic division of municipal court, have instituted a program with our public schools where speakers go in to talk about and focus on driver safety and the perils of distracted and aggressive driving. The court is committed to the welfare of our students, and we seek to broaden the audience of this program. We continue in our civil commerce court with the civil tax sequestration program, which in the last 3.5 years has collected over $68 million, half of which goes to the Philadelphia School District to help alleviate its funding. We also, on May 1st, 2nd, and 3rd, along with our justice partners and other agencies, will be having a safe return program that will take place at Enon Tabernacle Baptist Church. The purpose of this program is to allow individuals who have outstanding probation and parole bench warrants to come in, to surrender themselves in a safe environment, and to receive favorable consideration. There will be resources available there, as well as lawyers who will talk to each individual as they arrive to make sure that this is the opportunity that is appropriate for them. We are turning the church into a mini courthouse, and we'll have judges there to conduct on-site hearings, and there are also cases can be resolved. Additionally, I'd like to, in support of our strategic plan goal of supporting access to justice by providing safe and secure facilities, I must alert the administration about the concerns that we have about the declining condition of the Stout Center for Criminal Justice. The daily foot traffic here has taken a toll on the building and put a strain on the mechanical and operating systems, the elevators, the escalators, the courtrooms, the carpeting, the furniture, and furnishing. It is in need of a serious investment in these areas and upgrades to its systems and infrastructure. As a tenant in this building, the judiciary expresses its concern because we want to make sure that our employees are safe and that individuals we invite into the building as clients, defendants, or visitors are safe as well. Lastly, in addition to providing the delivery of fair, timely, and accessible justice to Philadelphians, the FJD should be recognized for its contribution to offsetting its costs and generating revenue and savings for other city agencies. As outlined in the testimony, in the written testimony, an investment in our courts, judiciary, and staff creates a return that positively impacts our justice partners, other city agencies, and our citizens. I thank you for the opportunity to present this oral and written testimony, and on behalf of the Philadelphia Judiciary, the Administrative Governing Board, the employees of the FJD, we respectfully seek Council's consideration and approval of our FY19 General Fund and Grants Revenue Budget. I'm happy to take your questions at this time.
Good morning. Thank you.
Good morning.
I'll be brief. exempts, 3% increase. Thank you for bringing it up, because if you didn't, I was. How many employees do you have that would qualify, and I guess the exempts versus the union? Because I know I've been getting a lot of calls and a lot of inquiries, and the most recent call I got that somebody said was my fault that, that people weren't getting a 3% increase pursuant to the authorized and appropriated dollar figure. And I'm assuming people they may or may not know that it's somehow related to the new pension proposal as it relates to the hybrid. So can you tell me how many people that would actually impact?
I want to have Mr. Cross.
Because a lot of people don't realize there are actually a lot of employees who work for the City Council of Philadelphia that are also stuck in the morass of a new pension plan.
Very well. And just so you know, before I let Mr. Cross respond to the numbers, because he has those, that I have been informing individuals as we've discussed about what some of the concerns or the reasons why that hasn't occurred. So
I just need to know how many.
Very good.
Because we got to get a sense of how many employees are actually impacted.
Councilman, this is Kevin Cross reporting. There are about 1,800 employees that are exempt employees for the 1st Judicial District of Philadelphia.
A lot of people.
Of Pennsylvania.
Okay, thank you. I'm good. Chair recognizes Councilwoman Blackwell.
Thank you, Mr. President. A general question. We get complaints from the people affiliated with the Juvenile Justice Center about folks being assigned there who are 18 and up, not juveniles. And it's creating all kind of problems, and they intimidate the younger people and all that. Do you have any say over that? Can you help us with that?
I will certainly raise it with Administrative Judge Murphy. If you could be more specific about what you're referring to.
Well, they're intimidating the young people, and they're taking over, and they're harassing them and beating them up because they're older and they're bigger. And the young people who are there, who are young teenagers, are losing out because they're under attack by older folks who are assigned there who are not juveniles.
Very well. And is this occurring in the actual courthouse?
I don't know where they are, how they get there, but they're at the Youth Study Center at 48th and
Okay, at the Youth Study Center. Okay, very good. All right, we will look into that and get back to you.
Thank you.
And if you have any specific cases or individuals, that would be very helpful.
All right, I'll ask them. Thank you. Thank you, Mr. President.
Thank you.
Thank you, Councilwoman. Chair recognizes Councilwoman Gim.
Thank you very much, Council President, and good morning, Judge Wood-Skipper. Thank you so much for your tenure over the last 5 years. It's been a real pleasure to be able to spend my first time on City Council getting to know the courts through you. It's been really helpful, and I appreciate especially our partnership on the eviction work and some of the work we've done about addressing youth placement, and would like to continue that partnership as you move into your new position.
Absolutely.
So later this month or later in May, our Council Committee on Children and Youth will be taking a look at juveniles in residential treatment. In 2016, about 950 youth were sentenced for juvenile delinquency. A number of them were placed in residential placement due to the lack of parents or guardians to take care of them. And, one of the things that I know that we've been talking about is the importance of having all children, even those that have some troubling backgrounds. They need family and family-like relationships to thrive. We also are fully aware that we've had some serious issues with some of our residential treatment facilities, whether it's Wordsworth or Vision Quest recently, that have required the sudden closure of them. Can you talk a little bit about whether the court has taken affirmative steps to ensure that youth are placed out of county only as a matter of last resort? And what efforts the court is taking to ensure that those placements address the trauma and emotional needs and social supports that those young people need at this time?
I can speak generally about that. I think each judge, as they are evaluating each individual and each child, is looking to do what's in the best interest of the child. And so I think we are all concerned as a system if individuals are placed in any inappropriate placements. And so that is high on the radar to make sure that the placements are appropriate. As I indicated, I think it would probably be beneficial to have a conversation with some of the family dependency judges in terms of looking at what the law requires and how that evaluation process takes place. But I can assure you that we are all concerned and want to make sure that we're doing what's in the best interest.
Yeah, thank you. And I know that we had talked a little bit about coming up with some common measures of the performances of these residential treatment facilities, particularly the out-of-county ones. We've noticed that there have been a lot of questions about the city's capacity and the state's capacity to effectively evaluate the educational component, for example. And so as we move later into the hearings, we'd love to just stay in touch with you about how to make sure the courts are part of that conversation.
Absolutely. Thank you.
Thank you. Similarly, we've been looking at our truancy system. I know from your testimony you spoke about the partnership between the city courts, the school district, and DHS to prevent and address and reduce chronic truancy. Truancy is also one of the main reasons that we found from a recent DHS study that this is a main reason why they end up in residential treatment facilities or begin to come into the system. As a result of this partnership, have the courts seen a reduction in families who are referred for truancy-related issues?
I'm not sure if I have those numbers to see if there was an actual reduction. I do know that it's something that the judges are certainly concerned about, and they consider and get information concerning, but I don't have those exact statistics. I'm not sure if they're in our general testimony, but I don't believe so. But I can certainly get that information to you.
Yeah, and some kind of longitudinal sense, like over the last 5 years, whether this partnership is improving that situation. Similarly, could you provide us with the number of cases that end up in family court after having been in the regional truancy court, and how many of those cases result in dependency? I think that would help us better understand how truancy moves from being you know, a situation that happens at the school, home, and the child, and then moves into the justice system. I think that's an important aspect that we're trying to better understand. You and I talked about this when we met a little bit, but you know, I shared some of the concerns about the recent news investigations by ProPublica into the impact of Immigrations and Customs Enforcement being present and picking up many people who are have no criminal record or history. They're often swept in through some of these seems like racial profiling sweeps that are going through, whether at traffic stops. They can come in through other places. And when we met with ICE, Councilwoman Quinones-Sanchez and I met with ICE 2 years ago, they were very clear that they were using the probation as a means to track potential violations of immigration. I understand that New York's probation department has a policy of limiting information shared with ICE officers, only allowing it if there's a judicial warrant, and not prohibiting it, any initiation of it by a probation officer. We talked about this a little bit, but is the court open to taking a look at its policy to help set clear lines which limit and define the kind of communication with ICE, so that we can go back and tell our communities that they don't have to be terrified about reporting for probation, which would bring them, if they did that, would bring them into a whole nother set of problems that they would then encounter?
So at this time, there is no written policy or unofficial collaboration between ICE and the probation department. The only time that the probation department gets involved is in handling any ICE request is in the same manner they handle any other request from law enforcement agencies. And that's where there is a valid detainer or search warrant from another law enforcement agency. And then they respond to specific inquiries, probationers who have criminal convictions, that dispositions which are a part of the public record. And so they don't treat the ICE warrant, if it's a legal, legitimate warrant, any differently. And I know we've talked anecdotally about this, and we've asked and we've met with some of the immigration advocates, and we've asked for specific instances and cases. But as I had people researching, in 2017, we were contacted by ICE about a dozen times where detainers were lodged. And as of earlier this week, in 2018, only 5 ICE detainees had been lodged, and each of those incidents were for defendants who have been under supervision with the sex offenders unit. There have been no general supervision ICE detainers ever lodged. So while we've heard these allegations or anecdotal stories about individuals reporting, we have no specific knowledge, and we still await, and even we left that message with the immigrant advocates to provide us with some specific information about specific cases, and we will certainly look into them. We are leaving the doors of communication open, and we will continue to discuss what, if any, additional policy the courts, and particularly the Adult Probation Department, should develop as it relates to ICE. So the communication doors are open, but I do encourage, if there are specific cases or instances that anyone is referring to, that you get the information to us, because otherwise we can't really explore it specifically.
Yeah, no, I appreciate that, and I would definitely appreciate the opportunity to stay in touch. I think that the issue is that ICE made it clear in the meeting with the councilwoman and myself that they were using probation, that they saw that as an open field for them to be able to pick up immigrants. So I'm not sure if it, you know, like putting the onus on some of the advocates to come up with the most extreme circumstance that they can manage to find. You know, I'm wondering if there's a way for us to keep working together, because I think that's what New York did, that they decided to be proactive when ICE made it clear. ICE's division made it extremely clear to us that they felt like probation was absolutely their purview. They had no problem utilizing it. They plan to use it. Whether or not we come up with the specific indications of it, would love to still keep talking to you about a proactive policy that we can use.
Absolutely.
Thank you very much. And then the last question I have is about the partnership that we've got on the city's task force on eviction prevention and response. I think that it's been a really important effort to help us resolve the disputes between landlords and tenants and keep families in stable housing. I really appreciate the work that the court has done to make the Lawyer for a Day project and the landlord-tenant legal services effective and helpful and located at the court, so it's not, you know, drawing in from other places. But one suggestion for additional reform that we've heard is the need for judges to review and approve the judgments by agreement, so that both parties understand their rights and the substances of what they're going into, so that the tenant, for example, doesn't feel pressured to agree to a rent that they can't possibly make given that their circumstances. Again, is this something that we can continue to discuss, such as improving the mediation process with the leadership, with the court leadership?
I'm sure we can continue with those discussions. I know that Judge Neifeld and her team meet regularly with all of the interested parties, Public Interest Bar, the Bar Association, and always working towards solutions for areas of concern. So those doors are always open, and we can certainly continue that conversation.
Thank you very much.
Thank you,
Thank you, Council President.
Thank you.
Thank you, Councilwoman. Chair recognizes Councilwoman Kiona Sanchez.
Thank you, and I'm going to be brief since Council President asked us to be. I appreciate all the budget details that you've provided. Could you tell me quickly, we in the city, we've been looking at performance-based budgeting. What methodology do you utilize in capturing your budget numbers?
We do not use the performance-based budgeting, Councilwoman, but we do capture our performance measures. We do track our expenditures by the departments and by at our smallest unit levels.
Speak into the microphone.
Yes, and we do capture our budget information at our unit levels. So it could be a process where we could marry our outcomes with our budgeting matters, budget expenses, and get to a point where we could get to performance-based budgeting.
That would be helpful. I mean, we're going through our little hiccups as we transition into that and have a pilot with some of our budget. Last year, when we closed out your budget, because of the zero growth budget agreement that we have, the courts were allowed to keep $3 million. How was that money reinvested, and can you provide to the chair the details around what those reinvestments got us?
We can provide that information to you.
Okay. Councilwoman talked about probation and ICE. Question, is anyone monitoring the referrals by the court system into treatment as we deal with this opioid addiction? And Councilman Green is doing some work around this issue, the issue of who gets referred for marijuana versus real treatment, because we need the treatment services. Is there any review of that going on? And
so we are constantly reviewing what we call our problem-solving courts, trying to determine if we need to have additional courts, trying to ensure that individuals are being referred to the appropriate court. So we try to look at individuals as early on.
How about when they're getting referred to treatment? We just wanted to, it would be helpful if you could provide, and I'm sure when Councilman does his hearings, we want to know who's being referred for marijuana, and if we're utilizing those types of resources that we need for opioid and some of the other work that we're doing. So it would be nice if...
All right, I can see if I will raise that with all the individuals who will doing the stats for, because I don't know right now if we separate them out by drug.
Right.
But I think that's certainly something we can do, and I could probably say anecdotally that the referrals for marijuana are probably getting much lower because of the opiate crisis.
That's what we're hoping, but it would be good if we could start putting those in categories and buckets so we can look at that as we move forward. And then in terms of some of your courts, you know, whether it was the eviction court or some of the other things, the other work that we're doing with the courts, what's the process that you review for performance for them? You know, drug court, mental health court. Is there a matrix that you're using around?
That's one of the areas where I know that we need to do some consistent approaches to how we're looking at data. And that's one of the things I know we have applied for a grant to have a coordinator who can coordinate that process so that we are consistently looking at the same measures in each court. We have courts, a municipal court, court and common pleas court, and you have different factors that come into play, and trying to find a mechanism or a methodology that will capture all of the information across the board is what we're hoping to do. So hopefully we'll get better at that. Each of the courts keep their own statistics, but some of them are keeping statistics on different things. So we want to make that more consistent.
Okay. One of the things that came up with the police overtime was the issue of police and courts. I'm assuming you've been part of the conversation about readdressing whether we want to do some of these preliminary hearings back at the police districts. Have you been part of those conversations? I
was a part of at least one conversation quite a while ago, and I know that Judge Neifeld has been involved in conversations as well, and I think these conversations are ongoing in terms of the feasibility of doing that. So I think they will continue and hopefully come to some resolution around
it was a pretty big number, and I know when the police department comes up, it'll be part of the many different conversations we're going to have. Lastly, and you can submit this to the chair so that I'm not taking up too much time, is there a plan for diversity, particular Hispanic hiring? You got your numbers are, haven't moved,
and we continue to work on that. We make specific outreach to diverse communities and try to advertise in diverse neighborhoods when they are opening, and we direct everyone obviously to the website where we do most of our online applications. So there is a progressive effort to increase our diversity hiring, and so it's certainly in the forefront.
Do you use our city's personnel office, or do you have your own?
We have our own personnel office.
Do you have a civil service process similar, or is it all exempt?
It's not.
It's all exempt.
It's all exempt, right?
It's all exempt?
Correct.
Okay, and then we should have a meeting and a discussion about that, because I understand civil service is a little bit more complicated, but, is it recruiting on community college, something, because those numbers are extremely low for the level of participation from our community within the court, unfortunately.
Absolutely.
Within the court system.
And we certainly will continue those conversations and certainly welcome any suggestions you have in moving that forward.
Okay. Thank you. Thank you, Mr. President.
Thank you, Councilwoman. Chair recognizes Councilman Jones.
Thank you, Mr. President.
Oh, wait a minute.
And it's still morning, so good morning.
All right.
There is a slogan now that has been in the sports world, particularly with the 76ers, and it is trust the process. It's hard to chronicle when the process started and what draft pick it was, or did we had to tank first? But Mr. President, I want you to know that we were asked at the University of Penn's Law School, we were on a panel about criminal justice reform and how things had evolved. In my mind of the process, it started with an organization, and was joined by others, but CJAB. And for years, you sat at that table, along with your colleagues in the Defenders Association and Probation and Parole, and talked about how we could do all of this. It took us a while to listen to you, but we have, and the results of all of this reform is because of the foundation that you guys started. And I wanted to say that on the record for the public to know that we're glad about all of the new way of thinking about criminal justice. But and I'm going to quantify it with the fact that things don't happen independently. When you go on I'm going to, have a stricter arrest policy, it impacts the prison, it impacts the courts, it impacts the DA, it impacts the Defenders Association. And for the first time in government that I saw, all of these parties come in a monthly way in a room and talk about those impacts. I remember Justice Doherty sitting right where you are saying, if we just would use GPS technology, and I think it was like 400 of them, you would reduce prison population. And he said it, you were co-signing on it, and I just want to say for the record that I'm glad we are at this space and time right now, but I want to publicly thank CJAB for that. Now, having said that, our job ain't done.
That's correct.
That we will constantly come in rooms and argue about issues such as ending cash bail in the city of Philadelphia to keep the needle moving in the right direction. But what I love about what we're doing is that we're not afraid of new voices anymore, that we're actually listening to differences of opinion and actually gleaning from those opinions sound public policy. So as we look at what the MacArthur Foundation has contributed to this process, as we look at, and in anticipation and a course correction from the new district attorney, I want to thank all partners for having the foresight to be in the right place at the right time so that we could all do the right thing. And I wanted you to hear that, because some of the stuff, Mr. President, she would get mad at us about, like jumping the gun, and you know how we are. Well, put it on me. No, I am. But they were patient enough to let us all sing in the same choir, and I am thankful for that.
And Councilman, I thank you for those comments. And again, I concur in the importance of working collaboratively together, because even if we don't all agree, we can work through the difference and determine what's in the best interest of everyone, and then recognizing that what the court does or what the DA does or what the defendant all has impact on some other agency, and consider that impact before making decisions.
So that's my kumbaya moment. Now I'm going to challenge us to look at some different things. Probation and parole and detainers. It is stated that yearly, this is costing us $42,000 per person on average, I don't know how they came up with that, but approximately $140 million a year in incarceration, people with detainers. Do you have a perspective on that?
I'm sure there is a cost, because there is a cost when people are detained, but I think we have to also recognize that the number of people detained has been greatly reduced over the past years, and we will continue to work on programs for alternatives to incarceration when it is appropriate, and looking at factors to determine when it is appropriate to incarcerate. I reiterate that the Probation Department model is not to detain and incarcerate. People are given opportunities, and that's not their first course of action. But also emphasize that in the past years, and particularly under MacArthur, the number of individuals detained has been greatly reduced, and I think that will continue to happen because of the progressive thinking and progressive programming.
So we had an opportunity to, along with members of your staff, to go up to Luzerne County. Luzerne County isn't big like Philly or Pittsburgh or Allegheny County, if you look at them, but their model of how they release with condition, which alleviates the stay of incarceration and subsequent cash bail, is amazing. So if there is a reason, you are either held because you are a danger to society and or yourself, or you're let go with condition. So me and you, we went out to the brew pub in my district, and I found out that you were a Boston fan, deep down. And one drink got into us, and we started fighting. Now, you almost threw me off the deck, because you're bigger than me. But the likelihood of me and you sober getting in that same fight wouldn't happen. So for me or you to spend 6 months in jail, lose a job, lose an apartment or a house, lose family relationships over that stay at a cost of arguably, and Julie Wertheimer always kicks me about the exact, I'm gonna say 130 a day, does not make sense for a $1,000 bail. So we're starting to look at, so maybe after that bar fight, because you're a Boston fan, we have to stay away from the brew pub, a stay away order, or you might need anger management, because you did almost throw me into the river. And those conditions allow you to come back and be president of this body. And for us to figure out how to put ourselves together as human beings in a holistic justice model, as opposed to the stagnant model that we are currently using, which kind of depletes the mission and causes other problems to incur. So I know the district attorney, who I'm looking forward to his testimony, is looking at that. I know that Keir Gray, who has been a long-term advocate for that. How do we figure this out in your storyline to kind of get more towards Luzerne County's model?
So I think there are a couple of things. So as you know, as part of CJAD, there is a separate subcommittee on prison population that meets monthly as well, and talk about some of the ways of decreasing the detained population. As a matter of fact, my numbers as of April 11th, 2018 indicate that of the total prison population, now there's only about, and there may be too many, but 5 to 6% that are detained on warrants or detained as alone. When we look at when individuals are being released, of course we consider public safety, and the purpose of bail is to ensure an individual's appearance at court. So one of the other factors that we still can't lose sight of is that if an individual comes before the bail magistrate and also from other history and cases has 10 failures to appear, then that has to be a factor that's going to be considered in that bail decision. But I think moving forward, we're all proactive in ensuring that only people who must be detained will be detained. And I think that's where we're headed.
So, Mr. President, in conclusion, 2 things have to be done. This is the next level. We have to cost account what these things mean. Do they save money? Do they cost more money? Where should that money come from? So those are budgetary commitments and decisions to a direction. That has to happen. But if we're questioning the quantification of these efforts, these collective efforts, all you had to do was be down on the second floor when we announced we're closing the House of Correction, and you know that this is working and we're moving in the right direction. So I want to thank you.
Thank you, Councilman.
Thank you, Mr. President.
Thank you, Councilman. For those that may be watching this on TV, just want to make sure that you understood that the scenario that the councilman just referenced was hypothetical. Never did we get in a bar fight. Never did I threaten to throw him in the river.
He's been mad at me in the
Sometimes
past.
people catch snippets and they say, man, I didn't know. I thought they were okay.
He's been mad at me in the past.
Thank you. Thank you, Councilman. Chair recognizes Councilman Green.
Thank you, Council President. I was going to make a comment on the record as being your pro bono counsel that the comments reflected by Councilman Jones do not reflect the body of City Council or the actions of our Council President. Good morning, President Judge Wood Skipper. Just have a couple questions I want to ask you. One, on March 5th, Councilman Jones and I sent you a letter regarding some of our questions regarding the arraignment court magistrates, and you sent a response letter back on March 12th, and then Municipal Court Judge Neifeld sent us a response on April 20th. And I just have some follow-up questions based on her correspondence and as part of the testimony this morning. Based on the information I've received, the Pennsylvania Rules of Criminal Procedure, Rule 528, allow the 10% deposit of bail. And then looking at the information that was provided under our local Rules of Criminal Procedure allows us to assess a fee equal to 30% or in the amount of 3% of the total amount of bail. One of the questions I'm trying to identify is how do we determine whether we're doing the 30% or the 3% as the local fee?
You want to answer that?
Can I give an example? If bail is set at $1,000 and 10% has to be posted, so it would be $100, then it would be 30% of that $100. So that's where the 30%. It's the amount of bail that is posted is set for poundage is based on the amount that is collected.
Right, but how do we determine it's going to be the 30% level or 3% of the total amount?
Because the $30 that's collected is actually 3% of the $1,000 of the amount of the actual bail. So it's 10% of what's posted or 3% of what the bail is.
Okay. And then also, I guess my question is, what is that? How are those dollars used?
I'm sorry.
How are those dollars used? That 30%, how are those dollars used?
Those dollars are returned to the city's general fund.
Okay, and that's used for the administration of the court. You say return to the general fund, but we also provide the dollars to the First Judicial District for your operations. So give me some perspective on how those dollars are used.
We could easily say that those funds are used to offset the court's budget, but they're also returned to the city's general fund for that they can be used in any way. We collect the money on a monthly basis and distribute them at the end of each month and distribute it to the city's general fund, to the treasurer's office.
Okay. But and I'll go back to the budget detail, you have expenses that you incur as part of the administration of this process, correct?
Correct.
Okay. And so what does that cost on a monthly or annual basis?
I'm going to have to get back to you on that, Councilman. The bail the funds that are collected for bail are not associated directly with our budget. We are fully funded by the City of Philadelphia. So these funds, if anything, would be just an offset to our budget, but are not returned to our budget directly.
Okay. All right, I'll follow up on that question. In the correspondence we received from Municipal Court Judge Neifeld, we got information regarding how the arraignment court magistrates are assigned. My understanding they're assigned for a 4-year term, and then after the 4-year, prior to the end of the 4-year term, they can be reappointed. And there's a committee that evaluates that reappointment process. Is there an opportunity for those outside of judicial branch or the public defender's office, district attorney's office, to comment or provide information on how those magistrates are being assessed?
I believe there is an opportunity because the committee and the courses that are taught involve not only the judges, but a lawyer from the district attorney's office and the defender offices, and they're always invited to come in and to engage in any conversation about concerns about the process in an informal setting, and so there's always an opportunity for them to have a voice.
Okay. But is there any opportunity for any members of the public or any other entities to make a commentary regarding how a magistrate, how he or she is performing their duties?
I will get clarity on that through Judge Neifeld, but I believe that any member of the public can make comments to the reviewing committee who will address any of those concerns based on the comments, and I guess if necessary could invite them in for some further discussion.
Okay. And is there any type of public announcement regarding when that committee meets regarding magistrates for reappointments?
That I'm not sure of, but I will check that to be sure. I don't want to give you an incorrect answer, so let me check that to make sure.
Councilwoman Sanchez talked a little bit about some work I'm doing in reference to opioid addiction and also the connection to medical cannabis, but also wanted to talk with you briefly regarding recent resolution that was introduced into this body, and we anticipate hearings in the Law and Government Committee regarding using THC as a screening process for probation and parole. I wanted to get your thoughts on that issue.
On using, I'm sorry?
THC, the chemical found in cannabis.
Right. I'm not sure how much of that is used at this point, so I think I'll have to defer my comment until I'm more informed about that process, but I can get back to you on that.
But would you be able to, would you or people from the First Judicial District be able to participate in those hearings?
I would need more detail about the nature and the specifics of the hearing, because one, if it's something that could come before the court where someone will have to make a decision, it could be a conflict. So I would need to know more specifics about the nature of the hearing and what information you need from us.
Well, the purpose of the hearing is to investigate and examine the use of THC screenings for people who are on probation or parole and whether we should continue to use that going forward. We won't be having any conversations regarding any active matters before the court, so more of a policy perspective and getting input from various entities within our criminal justice system on that policy.
I don't see why we could not have a policy discussion.
Okay. Also wanted to ask some questions. Currently, there's legislation in the Pennsylvania General Assembly by Representative Taylor regarding Jenkins Law Library. My understanding is that fees are collected by the First Judicial District, which are used by the Jenkins Law Library. My understanding that the legislation would change that process. Do you have any perspective on the legislation?
I don't have any comment on that legislation. That is not something that the First Judicial District put forward, and we are not permitted to comment on that per our Supreme Court.
I didn't hear the last part of your comment.
We're not permitted to have any conversation, any comment regarding that because it is a legislative matter, and we can't be involved in legislative matters.
Okay. Okay. Council President, I know there are some other members that want to ask questions, so in the sake of time, I'll allow them to ask questions and come back and make
Councilman, actually, just before you walked in, there was, I believe, to be an agreement that we would just do one round on this first panel because we got started so late. And we have 5 panels today, and we're 12 o'clock. So if you have some additional questions.
Well, I said because I see.
I promise to be lenient on the time. You got a couple of other questions?
I think I know where some of my answers may be going, so I will defer to Councilman Jones, who is in the gallery.
And I know the councilwoman just sent me a little. No, your time is not up yet.
Okay, well, I'll just say, in reference to some of these questions, hopefully we can have a follow-up meeting, maybe in my office regarding some of the questions, maybe yourself as well, or as well as Judge Neinfeld, so we can kind of get to the bottom of these questions.
Councilman, we are always open to further discussions and communication and keeping those lines open.
Okay, all right, thank you.
Good? Good?
Good.
All right, thank you, Councilman. Councilwoman Gim, I think you had one follow-up, brief follow-up. Yeah, thank you.
Earlier, you mentioned that the court honored the detainers that are lodged against some of the folks in probation. Could you clarify, are those ICE detainers or are those judicial detainers?
I indicated that there were 5 ICE detainers that were honored in 2018 thus far.
Right.
Those were detainers that were valid arrest warrants from just like any other agency that we would honor.
Generally, the Sanctuary City policy does require us to require a judicial warrant because the ICE detainers have had problems in the past that have gotten them in a number of troubles, including lawsuits. So maybe that's something we can continue to discuss. Thank you, Council President.
Thank you.
Thank you, Councilwoman. And thank you for your testimony. I do believe there is one callback day, so if there are any other additional things that may come up with respect to council members, you could be called back. And obviously, whenever there's a need to have further conversation, you've always made yourself available. So I want to thank you.
I will continue to do that.
Got the message about the exempt employees. There will be something on that very soon.
Very well. And thank you. And to all members of council, I thank you for this opportunity. This will probably be my last opportunity to present as chair of the AGB and president judge as my term ends in November, of course, unless there's a callback. But thank you. It's been a pleasure.
Thank you. And thank you so much for your awesome work.